Hey everybody, I'm Ross Myers with Bunker Munitions, and I want to talk about the New York State Rifle and Pistol Association versus Bruen case that the Supreme Court issued an opinion on a few days ago. So, what this case was all about is the may issue states. This one focused mainly on New York, but it also included California, New Jersey, Massachusetts, Maryland, Hawaii, Delaware, Connecticut, and the District of Columbia. So, what these were states that had concealed carry permits that you could get, but only for certain people. So, if you went through the application process and paid your fee, had your background check run, saw that you weren't a prohibited person from owning a gun, you may then be issued a concealed carry permit. All the other states are shall issue states. What that means is if when you go through the process, you shall be issued a concealed carry permit. And there's a lot of buzz about this case, thinking that it's getting rid of all these gun laws. Everything's going to turn into the Wild West. It doesn't do that at all. It's a very good case and it's going to set great precedent, but it doesn't just throw all existing laws out the window, and that is talked about in a concurrence with one of the judges that I'll talk about here in a moment. But the argument for the case is New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. All right. So, a lot of what this meant was the judge or whoever was in charge of issuing these permits needed you to show special need of why you needed it. Guess who had special need? Politicians, celebrities, rich, powerful people. Those were the ones that got issued permits. Your average, everyday citizen couldn't get a permit. Apparently, you did not have a need to protect yourself from muggers or anything that were to happen. You were on your own, according to these states. But the court opinion, I'm going to pull out some excerpts. I'll put them up on the screen as I read them. Try not to stumble through them, which you know I'm very good at. No New York statutes define proper cause, but New York's courts have held that an applicant shows proper cause only if he can demonstrate a special need for self-protection distinguishable from that of the general community. Again, you have to be a special person, someone distinguishable from the community. Special needs standard is demanding. For example, living or working in an area noted for criminal activity does not suffice. New York courts generally require evidence of particular threats, attacks, or other extraordinary danger to personal safety. I'd say living or working in an area that's noted for criminal activity is a pretty good reason to fear for my safety. If I live in a city that has one of the highest crime rates in the United States, you bet that I'm going to want to be able to protect myself walking down the street to the grocery store, to work, anywhere. In the court's opinion, they listed two examples of when concealed carry was used properly and it saved someone's life. I'll read those, and I've also got two more examples that have happened recently that I think deserve some attention because they're not getting attention because good guys with guns don't exist. It doesn't happen. We don't talk about those. But the two that were in the court opinion, one night in 1987, Austin Folk, a gay man from Arkansas, was chatting with another man in a parking lot when four gay bashers charged them with baseball bats and tire irons. Folk's companions drew his pistol from under the seat of his car, brandished it at the attackers, and fired a single shot over their heads, causing them to flee and saving the would-be victims from serious harm. On July 7th, 2020, a woman was brutally assaulted in the parking lot of a fast food restaurant in Jefferson City, Tennessee. Her assailant slammed her head to the ground and began to drag her around while strangling her. She was saved when a bystander who was lawfully carrying a pistol pointed his gun at the assailant, who then stopped the assault, and this assailant was arrested. So those are the two examples they used, and I want to show you or tell you about these two more. So this one in particular, this man is a hero. I'm going to put a picture of him up on the screen now because his name is Jack Wilson, and he did not receive near the credit he deserves for what he did to save the lives of countless people. On December 29th, 2019, a man named Jack Wilson was sitting in church when a man came in and sat down. He was known in the church by a few of the members for receiving food from their food bank. The criminal stood up, pulled a shotgun out of his jacket, and killed 2 people. Before he could shoot a third, Wilson acted quickly and saved the lives of more terrified people. Meaning, he stood up, pulled out his concealed carry pistol that he owned legally, and shot the attacker. Wilson was given the Governor's Medal of Honor for his bravery. And this one happened just a couple months ago. On May 28th, 2022 in Charleston, West Virginia, a woman who I tried to identify and find any news article that mentioned her name. I could not find any. I'm assuming she wanted to remain anonymous for pretty good reason. But she had a legally carried handgun, and she prevented a mass shooting at a birthday party. A convicted felon pulled out a rifle that he was legally not allowed to have and started firing into the crowd of partygoers. With her heroism, she shot and killed the shooter and saved countless lives. So, a woman with a legally owned pistol that she was legally carrying with a permit that she had saved the lives of everyone at that party. The shooter wasn't able to thankfully hurt anyone before she took action. And credit to her for being brave and standing up and protecting everyone that was around her. So I want to talk about the concurrence of some of the other judges and what they had to say. So the first is Judge Alito. He says, in 1791, when the Second Amendment was adopted, there was no police departments, and many families lived alone on isolated farms or on their frontiers. If these people were attacked, they were on their own. It is hard to imagine the furor that would have erupted if the federal government and the states had tried to take away the guns that these people needed for protection. Today, unfortunately, many Americans have good reason to fear that they will be victimized if they are unable to protect themselves. And today, no less than in 1791, the Second Amendment guarantees their right to do so. Side note on that, saying that there was no police in 1791, so you had to fend for yourself. Today, we do have police, but the Second Amendment, not the Second Amendment, the Supreme Court has ruled multiple times that the police do not have a duty to protect citizens. The duty of the police is to enforce laws and go after criminals. They do not have a duty to protect you and put their life over yours by trying to protect you. All right, Judge Kavanaugh also concurred. First, the court's decision does not prohibit states from imposing licensing requirements for carrying a handgun for self-defense. In particular, the court's decision does not affect the existing licensing regimes, known as shall-issue regimes, that are employed in 43 states. The court's decision addresses only the unusual discretionary licensing regimes known as may-issue regimes. They are employed by 6 states, including New York. So, again, this doesn't change laws saying that felons can have guns. It doesn't make it easier to get guns. It doesn't get rid of background checks that we run. It simply says that if you go through the proper requirements to get a concealed permit, you shall be issued a permit. There's nobody special. There is no second-class citizen when it comes to the Second Amendment. You can't give celebrities, politicians, the rich and famous, prominent people a right and deny it to the general public that New York was doing. You can't do that. He also goes on to say, nothing in our opinion should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in sensitive places such as schools and government buildings, or laws imposing conditions and qualifications on the commercial sale of firearms. Exactly what I just said. This opinion is great, and it's going to set good precedent. It's a step forward for the citizens of these states that feel they need the right to be able to defend themselves, especially if they live in high crime areas, anything like that. But it doesn't strip all the regulations away like a lot of things that are being reported and people seem to believe. It simply doesn't do that. It gives an even playing field for everyone to be able to access carry permits at the same level. No one special. All right. So, I want to look at the Second Amendment, and then I'm going to wrap this video up. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So, Clarence Thomas, on page 19 of his court opinion, said the following: its reference to arms does not apply only to those arms in existence in the 18th century. Just as the First Amendment protects modern forms of communication and the Fourth Amendment applies to modern forms of search, the Second Amendment extends prima facie to all instruments that can constitute bearable arms, even those that were not existent at the time of the founding. Seems pretty simple. We have the right to free speech. In the 18th century, that was town square. Shouting out your bedroom window, standing in the street, you could say what you wanted. We now have the internet, radio, TV. You also have freedom of speech on those platforms, even though they weren't around when these amendments or when these rights were written. So why should the Second Amendment be any different? Along those lines, with a lot of people saying that it only applies to muskets, things like that, I simply don't agree. The Second Amendment's not for hunting. It's not for Kevlar vested deer, anything like that. It's for protection, and it is for tyranny. It just is, whether that be foreign or domestic. A lot of people have said, hey, let's take all these, I think 20 million AR-15s that are in circulation in America and ship them over to Ukraine. Ukraine could really use those AR-15s that all these Americans have. They could. By God, I wish they had them. And the government is handing them out to anybody willing to take one. If we're very fortunate to live in America, where the likelihood of us being invaded by a foreign nation isn't nearly as high as some of those European, Middle Eastern, or Asian countries, but the possibility isn't zero. And if that were to happen, I do not want to be waiting in a soup line for my government to decide, now it's time for you to be able to protect yourself. Line up and get your rifle. I want to be able to have mine to be able to protect my family, my home, my friends, the people that I love when that time comes, if it comes, which I hope it never does. But one thing that I've heard a lot, and I really like the expression, is if you need a gun and don't have one, I promise you, you'll never need it again. So it's It's not a funny subject. It's not fun to talk about, but it's the truth. I think I'm going to leave it at that. The next video I do, I want to talk a little bit more about inclusion in the gun community and why there may be such a divide among people, that the stigma that the gun community has, what some people think, and people in the gun community themselves. There's a lot of people that are in the gun community that I believe are toxic for the community and toxic for our cause. That's the next video I have planned. But this one, we're moving in the right direction. So thank you, and I'll see you on the next one.